Well, the High Court ruling, which is not reported yet in the law journals, it is reported in the media, suggests that the local government cannot carry out prosecutions in their name under Section 120 of the Local Government Act, because such a section is unconstitutional. In 1997, I believe, in a case called Repco Holding against the public prosecutor, the High Court had declared that certain sections of the Securities Industries Act and the Securities Commissions Act, which gave power to the Securities Commission to prosecute in its name certain offences under the law, was also unconstitutional because it violated Article 154(3) of the Federal Constitution. 154(3) of the Federal Constitution basically gives the power to carry out any prosecution, to withdraw any prosecution, gives that power to the Attorney General of Malaysia, who also happens to be the public prosecutor. In Malaysia, the public prosecutor is the Attorney General. So since 1997, it became clear to those who knew the law that there is a difficulty with allowing persons other than the public prosecutor or the Attorney General to institute prosecutions for what we call criminal or statutory offences. So I think as a result of that, the government did make some amendments to the laws for certain other types. I mean, a lot of laws. I mean, every legislation you hold, there's some enforcement provision and some power to bring a wrongdoer to court. So the government has changed several pieces, but they have not changed a lot of other pieces, like the Securities Industries Act, the Securities Commission Act, all that has been changed. But Local Government Act, they didn't amend the Section 120. In simple terms, a local government or local authority cannot, in its own name, that means you can't have Majlis Bandaraya Petaling Jaya summon a particular individual and conduct prosecutions without the consent of the Attorney General. No, it is absolutely not safe to do that, and I would strongly advise the public not to read the newspapers and come to the conclusion you can throw your summonses away. And here's the reason why. For instance, in Petaling Jaya, since the 1997 Repco Lau decision, summonses are prosecuted in the name of the public prosecutor. It is not in the name of the Majlis Bandaraya Petaling Jaya. And each prosecution requires the consent of the Attorney General's chambers. So we are actually following what is got to be done. So when you receive a summons from Petaling Jaya, don't think it's the same. The problem is that not all local authorities may have practiced this as how it should have been practiced. So be very careful. First thing you do is pick up your summons and read your summons. Do you see the word there, Pendakwa Raya, on the top there? Or do you see something else there? And even if you see that you don't see Pendakwa Raya, please check, go and get proper legal advice, because the worst thing that can happen is if you completely ignore it, or if you and you turn up and you don't turn up in court, a warrant of arrest may be issued, and you'll have two police officers outside your house arresting you, and then you get into an argument and you said, I thought I could throw it away, so on and so forth. So don't ignore them. Well, they have power, but they should know what to do. And unfortunately, the Ministry of Housing and Local Government, since 1997, when this decision came out, they should have understood the implications and made the necessary amendments to the laws to allow prosecutions to be allowed by the Attorney General, to allow them to be prosecuted in the name of by officers in the local government. In the meantime, all is not lost. What you can do is you need to get the consent of the public prosecutor to institute the proceedings. If you don't pay a parking fine and if the summons issued wrongly, unconstitutionally, then that summons is going to be cancelled. But that doesn't stop the authorities from issuing a fresh summons, provided it's instituted by the Attorney General or the public prosecutor in their name and with the necessary consents, which can be done. Obviously, well, it appears so, isn't it? It appears that the Temerloh Local Council was not aware of Repco holdings against the public prosecutor, that decision, and the implications of that decision on the ability of the local authority to carry out prosecutions in their own name. Obviously, they did not know. In Petaling Jaya, we knew. The local council here knows about that, and so they have instituted all proceedings. It's instituted by the public prosecutor in his name. He's given the authorization for the conduct of the prosecutions by officers of the local authority. Well, a lot of people will obviously be able to get their cases discharged, not amounting to acquittal. Discharge not amounting to acquittal means the case is thrown out on a technicality, but it does not mean you're acquitted. You can be retried again. So basically, it's going to cost a lot more time, manpower and money to reissue everything back again, and everything will be delayed. So that would be probably the implication. Obviously, there's a question as to whether everything is backdated. What about earlier offences that somebody did 5 years ago, they paid the fine, can they go and take the money back? Now, in Repco's case, the court held that even if something is unconstitutional, the court has a power to state that it does not apply retrospectively. And that is what was decided by the court in Repco's case.